Joining us now to look at the nitty-gritty of the judgment culminating from the plight of the Ogoni people in the face of oil spillage ravaging their communities is the Counsel to the Ogoni people and a former Attorney General of Bayelsa State, Kemasuode Wode. Thank you so much for joining us on Newsday this afternoon.
Thank you very much for having me in your program.
Yes, now this judgment is surely a welcome one. How are the Ogoni people reacting to this current victory in court?
They are very excited about it. They are happy. It's been a long journey, but at least they've got judgment at this point. We await any further actions that will be taken by Shell. But as it stands now, the judgment our clients have at the Federal High Court is still subsistent, and it stands.
All right, there have been talks about a garnishee order and the fact that Shell has refused to pay. Talk to us about ensuring that this order is being followed to the letter, and are you confident that Shell will abide by this order? And also talk to us about, do you think Shell will want to even prolong this very protracted legal process by probably going to the Supreme Court and testing the judgment of the appellate court?
Several years ago, after we got the judgment of the Federal High Court, we applied to the Federal High Court for the enforcement of the judgment by way of garnishee proceedings. And garnishee ordered NISI. That's the first stage of the garnishee proceedings. An order was made. But the proceedings were stalled because in the course of the Court of Appeal proceedings, an order for stay of execution, further execution was ordered. So that garnishee proceedings was stayed. So with the striking out of the appeal, further actions will be taken in that regard to revive the garnishee proceedings that had been suspended because of the Court of Appeal proceedings that were then ongoing.
Well, like you said earlier, this judgment has been Okay, please go ahead. Please go ahead.
Go ahead, I'm hearing.
Okay, like you said earlier, this judgment has been a long time coming. You know, it has taken 22 years. So I'd just like to know how Shell has been reacting throughout this legal process. Were there attempts to settle out of court? Any claims, you know, of ownership or responsibility for what happened?
Well, as for whether or not they were the cause of it, the Federal High Court has determined it. Because in the Federal High Court, we called our experts, environmentalists, even valuers, land surveyors. They all confirmed the source of the spill as emanating from facilities belonging to Shell. And Shell called no expert witness. They called no witness, in fact, because the only witness they called went to court and said he did not visit the site of the spill and he had no technical knowledge. So, in essence, the case of the Ogoni people, the Sakpa family of Bidere, was not challenged. And that was the only witness they called. And it was on the basis of that the Federal High Court gave judgment. And they appealed. This is the second time. First, they appealed to the Court of Appeal. They failed to pay the correct amount of filing fees, so the Court of Appeal struck out the appeal. And they appealed to the Supreme Court, and the Supreme Court directed that they should return to the Court of Appeal for the hearing of the appeal, and then they should pay the complete filing fees, which they did. Then here again, we're in the Court of Appeal yesterday, and the Court of Appeal struck out the appeal because they did not provide some of the exhibits which ought to have been placed before the court for the determination of the merits of the appeal. And in fact, the justice of the Court of Appeal who delivered the judgment indicated that they called Shell, that's the numbers provided severally, and requested for the relevant documents, and they refused. That is what the justice who delivered the judgment in court said, and hence the case was struck out.
Curious behavior on the part of Shell. Yes, I'm sure you would. On the part
of Shell,
yes.
we have no communications with them. They have not communicated with us. So for us, the judgment stands, and whatever that can be lawfully done to enforce the judgment will be done.
Okay, regardless of the way they have gone about their appeals, do you expect that there will be some more challengings to this ruling in a higher court on behalf of Shell?
That is for Shell to determine. It's for them to decide. I would not want to speak for them. But just to say that in this particular case, the facts are very clear, and the facts were not challenged in the trial court. That is at the Federal High Court where the case was done. And that is the very foundation of the case. If you want to challenge the case on the facts of the spillage, the fact of the damage is at the Federal High Court, the trial court, that you challenge it. Those are not matters for appeal courts to deal with.
All right. How instructive and how massive is this judgment? How do you think this would probably serve as a judicial precedent for all the hanging cases moving forward? Talk to us. What's the magnitude of this judgment? How much crater will this create in that particular region?
The judgment is important. The only caveat is that the court was unable to determine the merits of the case where, in fact, some very important issues were raised. But apart from that, I think I should use this opportunity to talk about an issue which affects environmental litigation very seriously. And that issue is access to court for the determination of environmental rights. The Constitution has placed in the Federal High Court exclusive jurisdiction in matters of oil and gas, environmental spillages, and all the rest. But like a state like Bayelsa, there's only one judge of the Federal High Court. In Port Harcourt, I think there are about 5 judges. In Delta, in the area, in that Warri axis where they have these issues, only one judge of the Federal High Court. And in Bayelsa, you have over 10 to 12,000 cases in the Federal High Court. And I wonder how a single judge of the Federal High Court can entertain those cases. And as we speak, the Federal High Court does not have enough judges to go around most of the areas to deal with the environmental cases. So it's one of two things. Sufficient number of judges should be posted to those regions as Bayelsa and other states, or the jurisdiction to entertain those matters be made concurrent between the State High Court and the Federal High Court. And then, apart from that, a major disincentive in the prosecution of environmental rights action is the length of time it takes for a final determination of these matters. That is, from the Federal High Court that they start from, through the Court of Appeal, and then to the Supreme Court. It can take 20 years, can take 30 years, can take 40 years. And it's a big minus to the rights of the people to enforce their environmental rights. Thank you.
Now, apart from the issue of compensation, can you talk to us about any cleanup effort that has been made by Shell in a bid to, protect the environment, so to speak, for those that are living there?
The companies, particularly Shell, Ajib, the oil majors, the IOCs, do not carry out any major cleanup or remediation of the degraded environment. All they do is maybe a spill occurred in a waterlogged area, in the river, in the creeks. After 3, 4, 5 days of the spill, they will get people to go and scoop as much oil they can, that they can scoop from the surface of the stream or the river or the land. And then what about the crude that settled underneath? What about the crude that has flowed? No remediation is done. They don't pay compensation. They don't carry out remediation. No, what do they call it? The provisions they give to them, there's a name they call it, I can't remember. The provision they give to people and they send to places that have been devastated. Nothing. And all that happens is eventually the Shell, the companies, Nosdra, they call the parties and do some kind of contentious visit. What do they call this visit? To ascertain the cause of the spill and extent of the spill. Joint inspection visits. And they are usually contentious because there's dispute as to the cause of the spill. There's dispute as to the extent of the spill and damage occasioned. And that process is not objective. So there's always a dispute about it. You don't even see NEMA. Like in Bayelsa, there was a spill caused by ITO. It went on for 38 days. The spill was not stopped. No environmental remediation was done, no cleanup, no compensation was paid. And like in Bayelsa, the spills occur every day. Every single day there's spill. And the environment is not remediated, no cleanup, no compensation. So if you go to such states, the prevalence of cancer is something else. Go to the hospitals, people have cancer, cancer. Gas flaring. These are major issues which the government needs to address frontally. Thank you.
I mean, one would assume that within that 5.5 billion naira judgment, there would be some kind of provision for that environmental remediation, that cleanup, so to speak. What would it take in order to get the agencies that are, the local ones especially, to start on some of this cleanup, at least in the areas that are affected?
Well, it would involve making representation to the government at the center. They have some of their representatives locally, but they will tell you, they take instructions from those at the center. So it's really a difficult, and most of the people there, how will they even come to Abuja or go to wherever those people are to talk to them? They have no such access. And how do you get them to go and carry out cleanup? Look at the Ogoni cleanup that is being done. I don't know how far it's going, but there are agitations, complaints from the people. So and you can imagine the cost of that particular cleanup is very expensive. So it's not being done. It's a very serious problem in the Niger Delta, and it affects the entire country because damage to the environment in one area doesn't end there. It spreads across the entire area, even beyond the shores of Nigeria. So it's an issue which we need to take very serious cognizance of and take proper action. And recently, I was looking at the provisions of the Constitution, particularly Section 20 of the Constitution, which imposes on the state the duty to protect the environment. And the state was defined in the Constitution as including the federal government and state governments, amongst others. And by virtue of that provision, they can even make laws, and make laws to criminalize such pollution, such environmental oil pollution. They have the power to do that, and I expect that they will do that. And in fact, when I was Attorney General of Bayelsa State, I tested the right of the state government to institute an action for remediation of the environment and an order as well for the IOCs to pay compensation to the affected people. I instituted the action in the Federal High Court in Enegwa, and we succeeded, a landmark judgment, because of the principle that the state has the local standing to institute such action. Even though the damages that were awarded, general in nature, was about 1 billion, I think 1.2 billion thereabout, that was awarded against, that was a case against Ajib. And these are cases which most of the states should be doing. That is, for every spill, there should be an action to force the companies to carry out remediation of the environment and pay compensation to those affected, because most of the times the people are impoverished. They have no money to pursue their rights. It's expensive and it takes a lot of time. If something that can take 30 years, 40 years, you know what that means. Thank you.
All right, I want to say many thanks to you, Kemasuode, for your time here on Newsday.